Good afternoon, everybody. Welcome to the meeting. Before we go into the formal agenda and item number 1, I just want to remind all speakers of their allocated time, and if you can stay within that time frame, please, of 3 minutes or 5 minutes if it's in a different capacity. We don't have any additional time to go over, so at 3 minutes we'll be just moving to the next speaker. Thank you. Item number 1, then, membership of the committee. I think we're all here. Any apologies?
No apologies have been received, Chair. Are you substituting, Councillor Lawson? Yes. For who? Who are you substituting for?
Sorry, I'm substituting for Councillor Zahid Kahoot.
Thank you. Any apologies?
No further. There's no apologies, Chair.
Thank you. Okay. Item number 2 then, minutes of the previous meeting. Moved and seconded by Councillor Sokol. Thank you. Item number 3, declarations of interest and lobbying. We'll start with you, Councillor Sokol.
Yes, Chair, I believe I had the email received from, I think he was the objector or supporter on the last item, yeah? Article page 149. Well, I did not reply on that.
Thank you. Councillor Firth.
Yes, Chair. I've just received an email from Mohammed Akhtar Raz, which I acknowledged and no advice given.
Thank you. Councillor Davis.
Thank you, Chair. I've had a similar email. I have not replied to it.
Thank you. Councillor Lee Richards.
Same here. Thank you.
Thank you. Councillor Bellamy.
Yes, Chair. Item 15, same email as I think everybody else has had. No action taken.
I think there were 2 emails. There wasn't by Mohammed Akhtar Raz, obviously one on the 28th, which I think we're all referring to, and there was the one this morning at 10:23 a.m. Again, as everybody else, I haven't responded.
Thank you, Councillor McGrath. Councillor Lawson.
Nothing to declare, Chair.
Thank you. I have 2 declarations, both in relation to item 15 on the agenda. One was just the circulation, I believe, that everybody got, and then I got a separate one in my capacity as chair. The one as the chair, I did reply to say that it wouldn't be appropriate for me to make any comment ahead of the meeting, and the other one I just acknowledged. Thank you. Item number 4, admission of the public.
There's no private items, Chair.
Thank you. Item number 5, public questions.
None received, Chair.
Thank you. Item number 6, deputations and petitions.
There's no deputations or petitions.
Thank you. Okay, so item 7, 8, 9 and 10 were the site visits, and I just want to again provide a little update to members that the purpose of the site visit is to give members a better understanding of what is being proposed there. The purpose of the site visit is not for members to engage with either applicants or objectors. That should be done through our planning officers or our governance team. Thank you. Okay, then the first application, item number 12, is application for definitive map modification order. Mark.
Sorry, thank you, Chair. I'll just share my screen. So the agenda item is an application for a definitive map modification order to record a public footpath at Old Lane, Scapegoat Hill, Colne Valley, on a definitive mapping statement and 2 other discovered routes. My name's Matt Dradale. I'm the definitive map officer at Kirklees Council. My remit is to continuously review the definitive mapping statement, which is the legal record of public rights of way held under section 53 of the Wildlife and Countryside Act 1981. Another remit also includes the investigation of formal applications for definitive map modification orders submitted under section 53(5) of the Wildlife and Countryside Act 1981. The agenda item before the committee is not a plan application and concerns the determination of an application received in 2018 for a definitive map modification order to add a public footpath to the definitive mapping statement leading between Old Lane to Taylor Lane via the burial ground at Scapegoat Hill, which is known as Route 1. The application gave as evidence 22 user evidence forms and various pieces of documentary evidence. Upon investigation, officers discovered evidence of use of 2 other routes not claimed in the application or recorded on the definitive mapping statement. These are Route 2, which leads between Old Lane to High Street via steps, and Route 3, which leads between Old Lane to High Street via Vermont Close. The agenda item is therefore also with regards to determining whether or not to make a definitive map modification order in relation to these routes. Landowners and adjacent landowners were consulted for Route 1 in October 2021 and on all routes in May 2022, and their statements have been considered in Appendix B Officer Investigation Report. An evidence-gathering consultation was conducted with the public, user groups, ward members, parish council and owners-occupiers in November 2022, which is described in the committee report under the heading Consultation. 8 members of the public provided further evidence of use. Therefore, in total, there is available evidence of use by 30 people. The agenda item was previously considered by members at the district-wide planning committee on the 19th September 2024. At that meeting, affected landowners spoke in opposition of the application and officer recommendations, and members provided some comments. Members resolved to defer determination of the agenda item in order to undertake a site visit and walk the routes to further inform the determination to be made, which was undertaken earlier today. Officers have comprehensively considered the issues raised and provided a detailed response to each of the statements in a new document appended to the committee report titled Appendix B Committee Update. Whilst officers understand and sympathise with the issues raised by the affected landowners, officers note that no credible evidence was provided with regards to presumed dedication based on long use by the public, or to counter the officer's recommendation. The determinant of the agenda item is evidence-based and is a quasi-judicial process. Members must only take into account all relevant evidence and not take into account irrelevant factors. Members must bear in mind that if a decision is made to make a definitive modification order, this still leaves the landowners with the ability to object to any order under Schedule 15 of the Wildlife and Countryside Act 1981 and be heard by a planning inspectorate at a public inquiry. So Route 1 is shown leading between A to C by the pink lines. Route 2 leads from A to B to D and is mainly shown in yellow, and Route 3 leads from E to F and is shown in blue. As surveying authority, the Council has a statutory duty under Schedule 14, paragraph 31B of the Wildlife and Countryside Act 1981 to investigate the matters stated in the application, and after consulting with every local authority whose area includes the land to which the application relates, decide whether or not to make the order to which the application relates. The Council also has a duty under Section 53(2)B of the Wildlife and Countryside Act 1981 to keep the mapping statement under continuous review, and, as soon as reasonably practicable, after the occurrence of an event specified in Section 53(3), by order make such modifications to the mapping statement as appear to them requisite in consequence of the occurrence of that event. In this case, the event that is most relevant to the agenda item is specified in Section 53(c)(1) of the Wildlife and Countryside Act 1981, and is discovery by the authority of evidence which, when considered with all other relevant evidence available to them, shows that a right-of-way which is not shown in the mapping statement subsists or is reasonably alleged to subsist over land in the area to which the map relates, being a right-of-way such that the land over which the right subsists is a public path. Section 53(3)(c)(1) therefore relates to discovery by the authority of 2 separate matters. Test A, does a right-of-way subsist? To answer in affirmative, this requires clear evidence in favour of the appellant that a right-of-way subsists on the balance of probabilities and no credible evidence to the contrary. Test B, is it reasonable to allege that a right-of-way subsists? This is a lower threshold. Under Test B, it is necessary to show that a reasonable person, having considered all the relevant available evidence, could reasonably allege that a right-of-way subsists. If there is a conflict of credible evidence, and providing there is no incontrovertible evidence that a way cannot be reasonably alleged to subsist, then the Council should find that a public right-of-way has been reasonably alleged to subsist. The relevant statutory provision in relation to the dedication of a public right-of-way based on long use by the public is found in section 53(1) of the Highways Act 1980, which involves two questions of fact. So it states, where a way over land other than a way of such character that use of it by the public could not give rise at common law to any presumption of dedication, has been actually enjoyed by the public as of right and without interruption for a full period of 20 years, the way is deemed to be dedicated as a highway, unless there is sufficient evidence that there was no intention during that period to dedicate it. Section 31(2) of the 1980 Act. In a period of 20 years, it is to be calculated retrospectively from the date when the public right to use the way was brought into question, whether by a notice or otherwise. Returning to the relevant test under section 53(3)(c)(1) of the Wild and Countryside Act, if there is clear evidence of 20 years user as of right and without interruption, uncontroverted by any credible evidence to the contrary, and no incontrovertible evidence that the landowner had no intention to dedicate, then test A is satisfied. On the other hand, if there is clear evidence of actual enjoyment of the way for a full period of 20 years, but there is conflict of credible evidence in relation to the other issues, but no incontrovertible evidence, then test B is also satisfied. If there is no credible evidence of 20 years user, or there is incontrovertible evidence, then neither test A or test B is satisfied. If section 31(1) of the 1980 Act is inapplicable, the question of dedication must also be examined in the context of common law. The various pieces of documentary evidence has been evaluated in accordance with section 32 of the Highways Act 1980. The Officer Documentary Evidence Analysis is presented in Appendix B, Officer Investigation Report, under the heading Documentary Evidence Evaluation. The Officer User Evidence Analysis is presented in Appendix B, Officer Investigation Report, under the heading User Evidence Evaluation. So, for routes 1 and 2, for the purposes of section 31(2) of the 1980 Act, the public right to use routes 1 and 2 was brought into question by planning permission, approved on appeal on 24th November 2017. The relevant 20-year period is therefore November 1997 to November 2017. What happens after the ways have been brought into question is irrelevant to the operation of section 31(1) of the Highways Act 1980. The public do not gain an advantage from subsequent use of the ways after November 2017, and neither does the landowner gain an advantage by subsequent prevention of use after November 2017. Routes 1 and 2 are now partly obstructed by a gate and walls in consequence of development since at least 2023. Route 2 remains mostly available for public use, while Route 1 is inaccessible in part. The development of the property is an event that has taken place outside the relevant period of 1997 to 2017. The grant of planning consent or subsequent development of land has no extinguishing effect on any unrecorded public rights that may subsist. The developers were notified of the risk of works undertaken to the land over which the ways are alleged to subsist in 2020. Members must determine the agenda item based on the available evidence during the relevant period of 1997 to 2017 and the character and nature of the ways during this period, as shown in photos of the routes in Appendix C, Figure 7, and aerial photos between 2000 to 2018 at Figures 19 to 23. During the relevant period, 23 members of the public used Route 1 on foot, 10 at the start of the relevant period and 21 at the end, on a daily weekly frequency. For Route 2, 16 members of the public used Route 2, 9 at the start and 21 at the end, also mainly on a daily weekly frequency. The quantity and quality of use in the user evidence forms provides credible evidence that routes 1 and 2 have been actually enjoyed by the public, as of right and without interruption, for a full period of 20 years, between November 1997 to November 2017. A section of the routes from Old Lane to the burial ground was used for funeral events. An agent acting on behalf of a landowner stated that this resulted in public use being neither consistent, continuous, nor available. There is no evidence from user evidence forms that witnesses found their actual enjoyment of the routes physically interrupted by the owners. In any case where two uses coincide, the deference of one party to the other's use for a short period of time may simply be a matter of courtesy and de minimis. The allegation for Route 2 is supported by a 1952 conveyance, which annotates the steps leading to High Street as a public footpath. Therefore, for Routes 1 and 2, there is clear evidence of actual enjoyment of the way by the public for a full period of 20 years. There is a minor conflict of credible evidence in relation to one of the issues under Section 31, but there is no incontrovertible evidence that the landowner had no intention during that period to dedicate the way to the public. Therefore, Test B is satisfied and the allegation is reasonable. For Route 3, the public right to use Route 3 was brought into question by Locked Gate in 2010 and 2015 for the purposes of Section 31(2) of the Highways Act of 1980. Two overlapping relevant periods have therefore been considered under Section 31 of the Highways Act. These are 1990 to 2010 and 1995 to 2015. 11 users indicate knowledge use of the route, but only 5 witnesses indicated that they used the way during the relevant periods. However, one person only used the way to visit a family farm, which is a private right. One user had known the route since 1980 but did not indicate a start date for their use. And lastly, one user only walked the way once. The quality and quantity of public use is therefore not sufficient to show that the way has been actually enjoyed by the public for a full period of 20 years, and it is not necessary to consider whether use was as of right or without interruption under Section 31 of the Highways Act. The question of dedication was also examined in the context of common law. There is some evidence of reputation from landowners, residents and users that part of Route 3 is an old footpath, and it is consistently annotated as a footpath on Ordnance Survey maps. However, the Ordnance Survey maps include a disclaimer which rebuts the inference of public status, which states the representation on this map of a road, track or footpath is no evidence of the existence of a right-of-way. Additionally, the evidence of public use is insufficient to infer an intention to dedicate Route 3 by the landowner and acceptance by the public at common law. The claim that Route 3 subsists is not reasonable, as there is no credible evidence that the way has been actually enjoyed by the public for a full period of 20 years or when considered a common law. Therefore, neither Test A or Test B is satisfied. After considering the evidence and the relevant criteria, members have 3 options. The first option is for the Council to make an order to modify the definitive action statement based on the officer's recommendation. The second option for members is for the Council to make an order to modify the definitive action statement based on members' interpretation of the evidence. The third option is for members to decide not to make an order to which the application relates for Route 1 and the discovered Route 2. The likelihood or otherwise of any order attracting opposition should form no part of the decision. It is also emphasised that factors such as suitability, desirability, safety, maintenance, privacy, or whether the routes are currently obstructed by development are other matters that cannot be considered or taken into account under Section 3 of the Wildlife and Countryside Act. Should the committee choose options 1 or 2, members are also requested to consider the Council's stance regarding confirmation of any opposed order. It may actively support confirmation of its own order, or alternatively take a neutral stance. The officer recommendation is that officers be authorised to make a definitive map modification order under Section 53C1 of the Wildlife and Countryside Act 1991 to add 2 public footpaths with variable widths as shown on the updated indicative map. This includes a public footpath leading from Old Lane to Taylor Lane via the burial ground, subject to the limitation of a gate, known as Route 1, and the public footpath leading from Old Lane to High Street via steps, known as Route 2. It is also recommended that the Council confirm any order if unopposed. If an order is made and the objections are received and not withdrawn, and the matter referred to the Planning Inspectorate for determination, the Council actively support confirmation of the order at any public inquiry or hearing. And this is an indicative map showing the ways that are proposed to be recorded in a definitive map modification order. Thank you, Chair.
Thank you, Mark. Thanks for pulling this together and for your presentation and all the work you've done on it. I know there's been lots that's gone in. Thank you. So we have the first speaker, Claire Atkinson. Good afternoon, Claire. Welcome to the meeting. You have 3 minutes.
I am Claire Atkinson. and I live with my family, my husband and 2 sons, aged 8 and 10, at number 6 Old Lane, which is the house and garden affected by Route 1 of this application. You have been there on your site visit today, and following that, I just want to reiterate some points I discussed at the last meeting. First and foremost, we are not the developer. We are the family who bought this house to bring up our family and become part of the Scapegoat Hill community. The application for the footpath was made in 2018 when our house was not built. We are aware that the church sold the land to the developer to help with the upkeep of the church, and we have learned that the application was made in an attempt to scupper the development. We had nothing to do with that. We waited a long time to find our perfect family home and bought it at the end of 2023. That's 5 years after this application. We also understand that the applicant actually lives in Wales now, so they're very likely no longer interested in this. Committee, imagine you have bought your forever home with the dreams of raising a family and growing all together. You have 2 little boys who love running around the garden with the dog and playing football, come rain or shine. Then you have the prospect of an up to 5 metre wide public footpath through your main garden and driveway. Apart from making the garden and driveway virtually unusable, there are also clear issues of security, because presumably we would need to leave our gates permanently open. That means our little boys will be unable to play safely in their own garden, and anybody can walk straight past our house and through our garden at any time, even in the middle of the night. There are real human consequences of your decision today. The development, which we had nothing to do with, has happened. A family, my family, live there now. I would like the applicant and the committee to realise that they are not hurting the church here, they are not hurting the developer here, they are hurting me and my family, and you have the power to do something about that today. Thank you.
Thank you, Claire. So it's over to members. Mark, I've got a point of clarity before we go ahead. And it may not be relevant to this PROW application, but nonetheless it's a point of clarity. Before, during or after any part of this development, purchase, transaction or exchange, were both parties aware that there may be concerns and issues around public rights of way here? Thank you.
Thank you, Chair. Yeah, the developer was made aware of the risk of developing the property in 2019 and 2020, and was, as far as we're aware, the purchaser was aware in 2023 of the application and the investigation that was taking place.
Thank you, Mark. Members? Councillor Firth.
Chair, as you're aware, I asked for this to be deferred in the last planning meeting, so we could actually have a site visit and go have a look at the situation. And I'm glad we did, because it gave us a fuller picture. Rather, sometimes it's a bit dry when you look at pictures and just read a report. And I could well understand now the situation. And clearly, from what we've heard then and today, the developer knew full well that there could be ongoing problems, and I feel very sorry for the lady present. But the developer must, or should at least have made her aware that there could be problems going forward. And in the circumstances, it's very difficult, but if we pass this recommendation, the property owner will have an opportunity to appeal, I believe. It's a very difficult one, Chair, a very difficult one, and I feel for the family that live there. But nevertheless, you can't just build over public rights of way. I'll leave it for now to see what other members' comments are.
Thank you, Councillor Firth. Councillor Bellamere and then Councillor McGrath.
Yeah, thank you, Chair. Yeah, I mean, at the last meeting I said, I mean, I used to live in Scape a long, long time ago. And to be honest, I don't ever remember using that as a footpath, I must admit, because I'd just cut down grandstand. But as we've heard, the developer knew, and to be honest, I do sort of remember that planning application from them houses, and I do seem to remember it being said that there would be problems at some stage due to a public right-of-way. We've already, we're aware the developer knew. Now, I would have thought the developer should have told the homeowner, the person that was buying, and I would hope they have, which, in that case, I don't think there's a lot we can do, to be honest. It's just going to be a, buyer should have been aware situation. So, yeah, I'm in agreement with Councillor Firth, to be honest. There would be that opportunity to appeal and, let the inspectorate decide, to be honest.
Thank you, Councillor Bellamy. Councillor McGrath.
I mean, I agree with what's been said before. It's a dangerous precedent to let developers build over contested land, and if everyone did due diligence, everyone would know that it was contested. It's not difficult to find planning when buying a new home, and whilst it wouldn't be the person buying the home per se that had to do it, but I'd like to hope a solicitor involved or someone doing an inspection on the house, the land, in advance would have made everyone aware. And if not, it's a failure in due diligence, but that's not our fault, nor is it the fault of the community that has a right of way. And as such, if we were to get to the point where somebody lives there every time and just go, oh well, now someone lives there, let's get rid of the right of way, then that leaves it leaves a dangerous precedent for all developers just to build on it and hope for the best as quickly as possible. And how many issues are we going to have? At least if we do back the right of way, as the officer recommends, then it sets the stall out that developers don't do this, or at least let everybody know in advance. And if that brings the house price down for the buyer, and they're fully aware of how it's done, there's no remedial work, there's no it's black and white, everybody knows where they stand. If we let this change and say, well, now it's built on it and we feel really bad, and it is a horrible situation, by the way, and if that was my house, I'd be in that chair now saying the exact same thing, but hopefully my solicitor, the inspector and everyone involved would have let me know, and I would have been aware and would have tried to drive the price down before I bought the house on the off chance that this went against me. But it would seem like that in every way this was always going to happen. So we can't just change our minds last minute. We have to stick by our guns, and we have to make sure that, and I'll be backing that the right of way on all two routes are kept open.
Thank you, Councillor McGrath. Councillor Sokol.
Thank you, Chair. I'm on the same opinion with my colleagues around here. Yeah, on the last meeting I was here, we deferred this application to look around the issue raised by the neighbors. That time we had a full sympathy with the whole. But now, because we heard and we are very clear, developer knew about that, it was developer's job to let the customer or who was buying the house, let know. He might have kept in dark all those purchases. So this application route order has been approved by the inspector. It's very difficult for this committee to go against that recommendation and go back against the officer recommendation. That's my thank you.
Okay, so we still don't have Okay, so it's been moved by Councillor McGrath for the officer's recommendation to approve the order. Seconded by speakers on this, so I think we'll go to the vote. Andrea.
Okay, so we're voting on the officer's recommendation as set out in the report. Councillor Sokol.
For.
Councillor Firth.
For.
Councillor Davis.
For.
Councillor Lee Richards. For. Councillor Bellamy.
For.
Councillor McGrath.
For.
Councillor Lawson.
For.
Councillor Uller.
For.
So that's carried. Thank you.
Thank you, everybody. Okay, the next application is on page 117. That's the erection of 8 dwellings and association works, land off Marsh Lane, Shepley. Sorry, Edward.
Thank you, Chair. Good afternoon, members. My name is Edward Cheseldine, presenting on behalf of Nina Sayers, the case officer. This application is for the erection of 8 dwellings with associated access and external works at land off Marsh Lane in Shepley. The application is brought to committee due to receiving a significant number of representations contrary to officer recommendation. 70 representations were received in total, 67 in objection and 3 general comments. The application site is unallocated within the Kirklees local plan. The site is an L-shaped vacant plot of land set to the rear of 119 and 129 Marsh Lane. The site is grass covered and borders greenbelt land to the southeast and residential dwellings to the northwest. There are 5 trees along the southwestern boundary which are protected by tree preservation orders. The proposed development is for 8 residential dwellings with associated amenity space, parking and access. The properties all have off-street parking spaces and plots 4 to 8 have integral garages. The site would be accessed off Marsh Lane, adjacent to 127 Marsh Lane. Throughout the course of the application, it was requested by officers that the scheme incorporated semi-detached dwellings to be more in keeping with the existing housing mix on Marsh Lane. It's noted that representation also raised concerns regarding the size of the proposed dwellings and the need for smaller, more affordable housing. Therefore, whilst the application has increased the number of dwellings, the footprint has not significantly changed. The applicant proposed to change 2 of the detached dwellings into semi-detached properties, taking the scheme to 9 dwellings. However, following discussions with Highways and the requirement for the width of the proposed access, it was not possible for the dwellings fronting Marsh Lane to be semi-detached, so this was revised, taking the final number of proposed units to 8. So, excuse me. The applicant is proposing access to the dwellings adjacent to 127 Marsh Lane. The access shall be built to adoptable standards. The TRIX database estimates 4 vehicle movements in and out of the site in the morning and afternoon, which is considered to considered to not have a detrimental impact on highway safety. The internal layout would allow for turning within the site and turning for refuse vehicles. Subject to condition, KC Highways DM have no objection to the proposals. The final revised scheme comprises 6 detached 2-storey dwellings and a pair of semi-detached 2-storey dwellings with living accommodation in the roof space. All dwellings would be predominantly finished in stone under slate roofing. Officers consider the proposed design and materials to be in keeping with the existing development on Marsh Lane. Plots 7 and 8 propose aspects of timber and aluminium cladding to the rear, which would not be visible from Marsh Lane and would be in keeping with the agricultural nature of the wider site context. Full details of materials would be secured by condition. As such, officers have no concerns regarding visual amenity. The application site is to the rear of the existing dwellings on Marsh Lane, all of which have primary inhabited openings in the rear elevations. As outlined in the detail in the committee report, the scheme would comply with the required separation distances between the existing and the proposed properties outlined in Principle 6 of the House Builders Design Guide SPD. Therefore, officers have no significant concerns regarding the impact on residential amenity. There are 5 protected trees along the southwestern border of the site. It is noted that the initial arboricultural information discounted one of the trees, and this was raised by representation. Revised arboricultural information was submitted, including an assessment with all 5 trees, and it was concluded that there would be no significant harm. KC Trees do not object to the proposal. The applicant is proposing to provide biodiversity net gain off-site, which needs to be secured. Therefore, officers are recommending the decision is delegated back to officers to secure the B&G agreement. This proposal has been assessed against all relevant local and national planning policies. For the reasons outlined fully in the committee report, the proposed scheme is recommended for approval subject to conditions. Thank you, Chair.
Thank you, Edward. Thank you. So the first speaker on this item, Stephen Armitage.
Yeah, good afternoon, everybody. Thank you for your time in allowing me to represent the residents of neighbouring properties in the immediate vicinity of the proposed development off Marsh Lane, Shepley, and to give you a practical insight into day-to-day living on Marsh Lane. The neighbours appreciate the challenge you are having delivering much-needed housing stock across the Kirklees area. However, we also believe it needs to be of the right house type in the right location. It is the neighbours' opinion this is clearly the wrong type in the wrong location. Although there are numerous areas within the application we believe warrants objection, as detailed in the many comments submitted to date, such as conveniently missed off trees, conveniently missed existing buildings, the continuous adjustments of plans when errors have been highlighted, still no clear explanation of how drainage against gravity will be achieved. It is called Marsh Lane for a reason, with flooding cellars a regular occurrence in properties on the street. However, I would like to highlight the main area of concern for neighbours, that being the significant day-to-day safety risk posed for in particular residents in the immediate vicinity, though also residents of the development, and also pedestrians and motorists in the wider context of the village, with vehicles constantly entering and exiting the proposed development. As you will note, the entry and exit being onto a notoriously fast section of Marsh Lane, where the 30-mile-an-hour limit is rarely adhered to. Councillor John Taylor has often muted the need for traffic calming measures, unfortunately without success, as it being a rat run for neighbouring villages to the likes of Newmill, Honley and Home Firth. This is clearly of serious concern. Having lived in Shepley for over 24 years and with 4 years on Marsh Lane, this proposal is no small infill of 2 or 3 houses, as with other similar so-called infills on Marsh Lane. This is clearly a cul-de-sac type development, though with no circular area at the end for vehicles to turn around or children to play. The planned layout and dwelling density being cramped and overdeveloped, and therefore completely inappropriate for the size of the plot available. Assuming 2 cars per household, this equates to a minimum of 16 vehicles entering and entering the development onto Marsh Lane, with trips to schools, shops and work. By example, Shepley First School is full in some cohorts. My 5-year-old granddaughter who lives on Sharp Lane has to travel to Shepley First School, as do others nearby. There will also be visitors, waste collection, constant flow of delivery vehicles, Amazon, DHL, Royal Mail, etc., who will have little alternative but to reverse at some point due to lack of appropriate turning. Even the residents of Plot 8 have no ability to exit or enter their own plot without reversing across other plots. As you will have also seen, the development is also directly opposite Marsh Lane with its constant flow of agricultural vehicles. In summary, the neighbours fear for the safety of village residents. A combination of speeding traffic on Marsh Lane, vehicles entering and likely often reversing out of the proposed development, and the blind spots articulated above is, in our view, a serious accident in waiting.
Thank you, Mr. Armitage. Next speaker, Nick Willock.
Members, the copy plans you have in front of you show the mature tree as surveyed through the tree consultant, but it is then represented as a smaller tree on the proposed layout. However, if this tree is shown accurately, it is actually only 2 metres away from the south elevation of the nearest plot, and the patio area would encroach into the root protection zone. The consequences of these inaccuracies in the plans is that this mature tree, even if it survives the development process, will impact on living conditions because it's too close to the south elevation and, I predict, will be removed within 5 years. These plans are therefore misleading and need to be corrected so that you can make an informed decision on the issue of tree protection. However, there are much more serious issues with the plans. The importance of a 43-metre long visibility display on a 30-mile-per-hour road is so that a car travelling along the road can have the required 43 metres worth of stopping distance, and the driver pulling out can see that car at 43 metres. Any less than that, and the two drivers cannot react in time, and a collision is much more likely to occur. I've conducted a formal survey of the visibility displays, and it is a matter of fact that the plans are incorrect, and the eastern visibility display cannot be achieved. Instead of 43 metres, only 19 metres can be achieved. That's less than half the required distance for a vehicle to safely stop. The update report suggests that the setback can be reduced to 2 metres instead of 2.4 metres. We were informed yesterday that Manual for Streets allows for a reduced setback. However, this is what Manual for Streets actually says on the matter, and I quote, "An X distance of 2.4 metres should normally be used in most built-up situations, as this represents a reasonable maximum distance between the front of the car and the driver's eye. A minimum figure of 2 metres may be considered in some very lightly trafficked and slow-speed situations, but using this value will mean that the front of some vehicles will protrude slightly into the running carriageway. The ability of drivers and cyclists to see this overhang from a reasonable distance and to manoeuvre around it without undue difficulty should be considered. These important matters of how busy Marsh Lane is, what speeds are, and what are the safety implications of allowing substandard visibility displays have not been addressed in the time available within the report in front of you. And so responsibility for this lies firmly at the door of the applicant in presenting accurate plans for officers and this committee to consider. I'm afraid you have therefore little choice today if you're going to make an accurate and informed decision, but to either refuse this case or defer the application so that revised plans can be submitted and properly assessed, and you therefore avoid the risk of making a decision today that could legitimately result in serious highway safety issues. Thank you.
Thank you, Nick. I just allowed a little bit of extra time because I pressed it late. That's all it was. Thank you. Okay, so the next speaker, Jake Hinchcliffe. Good afternoon, Jake. Welcome to the meeting.
Good afternoon, Chair and committee members. I'm Jake Hinchcliffe from Orange Design Studio in Murfield. We form part of the design team working on this application on behalf of Thurstonland-based Halstead Homes. We initially submitted a pre-application consultation in 2023. This received positive feedback from officers and consultees. Given this, the extant planning permission and the other previous planning approvals for residential development on the site, we progressed our scheme towards a detailed submission. Subsequently, after the consultation process, we received further constructive feedback from officers and consultees regarding the density and layout. We've also taken into account a number of comments received during the public consultation period. Alongside this, there have been a number of technical challenges during the application process, which relate to the retained protected trees and the proposed site access. These issues have constrained the site, but working closely with our consultants, planning officers and the Council's own consultees, we have overcome these challenges for a positive outcome, and no further technical objections stand from the tree officer or highways or drainage. The proposed access point has been relocated approximately 750 millimetres to the west of the site to ensure the access point is compliant and in line with highways officers' comments and recommendations. The proposal now seeks the approval for the creation of a small development of 8 homes with associated highways and landscaping works. The site presents a good quality, mixed house type development based in a sustainable location which will contribute towards the much needed housing stock. The proposed house types are largely in keeping with the traditional aspects of Marsh Lane and the wider Shepley area, and are also of traditional styles using local materials to help further contribute to the wider street scene. To conclude, the proposal now seeks to build a good quality and well-planned development on an appropriately positioned site that will contribute to the area, and I would respectfully ask that the application can be supported following the Planning Officer's recommendation for approval, so that we can deliver this site in 2025. Thank you, members, for allowing me to speak on this application today, and if you do have any questions, please do let me know. Thanks, Chair.
Thank you, Mr Hinchcliffe. Thank you for all speakers. So, over to the committee then. Any comments? Councillor Sokol.
Yeah, the agent have mentioned about the tree safety, yeah? He said they would be at risk because the development will be going too close to that protected tree. Is there any officer who can explain about it? There is no risk or any risk to the trees?
Thank you, through you, Chair. So yes, there's been no objections from our tree officer at paragraph 8.5. So there's been no objections from our tree officer, and all agricultural reports have been submitted. The 5 trees that you saw this morning, when we were on site visit, they won't be disturbed, and the canopy and the root protection orders all are suffice. So to confirm, there's no objection from the trees officers.
Thank you. Councillor Firth.
Thank you, Chair. There has been some comments about egress from the site from the objectors, and I'd like, although I've read a lot of it in the papers, I'd like our highways officers to actually comment on that and refute them, please, if that's possible.
Thank you, Councillor Firth. Councillor Bellamy, and then Councillor McGrath.
Thank you, Chair. I know I've got a question as well. Was the parish council consulted? Because it is in a parish council area and I can't see anything. And obviously, I mean, I know ward councillors are being consulted, but has any of them come back with any comments? Because I can't see any of them neither.
Councillor McGrath.
Thanks, Chair. Just going back to the egress comment, I'd love to hear from Highways about this site, because obviously they've approved it and the recommendation has come through. Obviously, in terms of visibility, there was the mention numerous times of the problems with reversing out onto a main road. The house next door, May 2023 on Google Maps, has a car parked so that it will reverse directly out onto that road. There's parked cars all the way up. So visibility, is the parking of cars on that road factored into the decision? And if so, is there a mitigating circumstance, i.e. they will have to edge out into the road anyway to see past parked cars on the road, of which is visible when you're looking on the road. And just clarification again on the obviously informed comment made by the objections regarding site and stopping distances, which have been mentioned, that not working in highways, I wouldn't be 100% sure whether they are correct or whether there are mitigating circumstances based on other aspects of the road. Thank you.
Thank you, Councillor McGrath. So I think Ryan will bring you in.
Through you, Chair, Ryan Kinder, Highway Development Management. The applicant has submitted visibility displays on the plans as part of the submissions, and they have demonstrated 2.4 by 43 metres. Now, it is acknowledged that the visibility envelope cuts across the adjacent neighbour's wall by circa 100 to 150 millimetres. There is a gate post in addition that's in the ownership of the applicant, which is to be removed to improve that. Now, there can be a relaxation of the visibility displays, as in line with Manual for Streets too, where you can reduce these down to 2 metres by 43 metres, should the circumstances permit. Now, the factors included in that are the existing road width. Now, Marsh Lane is 7 metres wide. It needs to be a minimum of maintained of 6.2 for buses, which would achieve that. Now, in this instance, we would not need to go down to 2 metre setback. Due to the 150mm shortfall, it'd actually be 2.25 by 43, which would give vehicles a projection of approximately 150mm onto the road. Just to further add to that, the site's been assessed by not only myself, colleagues in highway safety, colleagues in section 38 to deal with the adoptions, which they look at the visibility also. And the site has been subject to an independent stage 1 safety audit and designer's response, which has not received any objections or concerns regarding the visibility onto this road. It is of a similar nature to other developments within Kirklees that have this issue and have been approved both officer decisions and committee decisions. So overall, highways think that it's acceptable from a highway safety perspective and raise no objections in that respect. Thank you, Chair.
Thank you, Ryan. Councillor McGrath, did you want to come back?
Yeah, sorry, I'm happy with the highways and obviously not just you, but other members are professionals doing their job fine, so I've got no questions regarding that. Going back to a comment made, and I don't know if I'm allowed to refer, he mentioned the route protection order. Is that something, could we just clarify exactly what's meant by that, and if we are encroaching upon that space, and if that is a legitimate reason to object? Just going back to, like I said, someone who was involved in that industry bringing that comment forward, I know that Councillor Sokol brought it up that there's no objections from the tree consultants. However, there was a specific mention of a route coverage. I'd just like that one covering.
Thank you very much. So just to come back on a couple of points. So Councillor Bellamy, you asked about the parish council. So all statutory consultations were completed and the parish council was consulted and responses were to be due back by the 22nd of June 2024, but we didn't receive anything. In terms of your comment to do with the route protection order, route protection of the...
Yeah, worded it wrong, my bad.
Yeah, of the protected trees. So as you'll have seen from the update that was published yesterday, again, to reiterate, there's no objections from our tree officers, and the submitted agricultural surveys conclude that other than the parking areas, but these parking areas can have such things as what we call a cellular confinement system. So these are matters that are sort of a mechanism that can be used that is appropriate for using within these protection areas, and that can be conditioned through
Oh, perfect. Okay.
Thank you, Councillor McGrath. Councillor Sokol.
I've finished, yeah, don't worry. Oh, sorry.
Thank you. Chair, I've been on the site visit this morning. I've seen the situation there. This piece of land, it looks like very derelict. It's not well maintained by the people, by the owner. Yeah. I think this sort of development, it will improve the area. I know there traffic is increasing everywhere. Marsh Lane is a very wide roads, yeah. So I don't think there will be any problem if we approve this, go along with the officer recommendation. And second thing, the approval have been given outline for a number of time in the past, yeah. It's very difficult to refuse this application, so I go along with the officer recommendation.
Are you formally moving the recommendation?
Yeah.
Okay, so so it's been moved by Councillor Sokol for approval officer's recommendation. Councillor McGrath has seconded that. Councillor Bellamy.
I want to make a comment. I mean, I'm not saying that there isn't an issue on Marsh Lane. I mean, I can imagine, yeah, you probably get a lot of speeding traffic and all the rest of it. But having been on the site visit and actually stood in that entrance and seen what the splays are for exiting, that is actually quite good compared to some that we have seen. I mean, there's some that I've tried to drive out of, so I don't see that as being an issue as such. My only thing would be, can we make sure the materials are in keeping with the rest of the area? So it needs to be stone and it needs to be etc. That would be.
Councillor Lee Richards.
Thank you, Chair. Can we just make sure that the in the conditions the officers put in the ones about protecting the trees with the permeable parking areas to protect, because those trees are under tree preservation order, I understand?
Yeah.
Yep, so I'll just come back on a couple of points there. In terms of materials, we've got condition 4, which would be your standard materials to match, but they'll be finished in natural stone under slate roofing, so it's just a standard. So that's the materials that we've got there. We've got several conditions to do with the construction phase of the areas to be surfaced and drained, which could take on that special material for it, but we can certainly put a condition on that the material used within that surfacing is that, but also the agricultural surveys would be part of the plans table, so any recommendations in that would be put forward in there, but we can certainly add any additional conditions that doubly ensures that.
Thank you.
Thank you. Councillor McGrath.
Yeah, again, just going back to the objections, which obviously are very valid, and I do want it noted that we've listened, and I feel that the answers given were more than enough from the professionals regarding them. There was one thing, though, again, going back to the trees, there was a suggestion that they might not last 5 years. If that were to be the case, do we enforce anything? Is there, if what we do does affect the tree and it dies within 2, in 3, in 4 years, is there anything we do, or are we saying we've passed it, we're happy that nothing will happen to that tree, or it's died, or well, or is there some enforcement, or is there some sort of check, or is there something to protect the tree that's closest to a dwelling that we talked about already, or are we happy once it's signed off, if anything were to happen in the short term, we would go and somehow rectify that, whether by planting another somewhere else or making sure we make decisions that are more appropriate in the future. Where do we stand with it, with a tree dying in 5 years?
Sorry, through you, Chair. So what was the point about the 5 years?
There was a mention, and we can go back to him. He said that the going into the root protection area, that the tree may not survive 5 years was a specific
I'm just making sure that I've got
comment. Yes, sorry, I just wanted to make sure that was.
I just wanted to make sure that I understood you correctly. So as I've said before, the submitted agricultural surveys will have contained that information, and it's only the parking area, which I've said previously, and that will be constructed with the cellular confinement system, will be part of the approved plans. But also all developments taken outside the root protection areas. In terms of additional trees, it's not something that we could fully enforce, but that the surveys are stating to us that there will be no impact on those TPOs, and that anything further forward they would have to build in accordance with the plans, therefore, and there's no objections from our tree officers. Does that satisfy?
Sorry, not really. So I'm saying that dies in a year's time because of this development. That tree dies because of that development, quite obviously proven to. I'm not saying it will, and hopefully the report is bang on. If that tree dies in a year and falls over, what happens?
Thank you, through you, Chair. As it's a TPO, it has a level of protection that would enable us to have enforcement action, and then it's got a level of protection there. I'm saying there will be no impact, but the protection is there in order for us to,
Thank you. I think that there aren't any further comments. Thank you, Edward and Ryan. So I think we'll go to the vote. Andrea.
Thanks, Chair. So the vote is to delegate the approval of the application to officers. Councillor Sokol. Councillor Firth. Councillor Davis. Councillor Lee Richards.
4.
Councillor Bellamy.
4.
Councillor McGrath.
4.
Councillor Lawson.
4.
Councillor Uller.
4.
That's carried. Thank you.
Thank you. Next application, page number 135, planning application for change of use dwelling C3. Edward.
Thank you, Chair. Edward Tresaldine, Planning Officer. I'm the case officer for this application, which is for a change of use of a dwelling to a children's residential home at 18 Kingfisher Way in Dewsbury. The application has been brought to committee due to receiving a significant number of representations, contrary to officer recommendation. 30 representations were received in total, 27 in objection and 3 in support. The site is allocated for housing development under the current local plan. However, it is noted that the purposes of the allocation have been fulfilled and there are no other allocations for the land. The site is a rectangular plot with a modest front and rear garden space. The building is a 3-storey mid-terrace property. To the front, there are 2 off-street parking spaces. The property rests within a residential housing estate. Houses on the street are similar in age, whilst varying in terms of size and architectural design. Although the application was not accompanied by a planning statement, throughout the application it was requested by officers that details relating to the care use of the site were provided by the applicant. The proposed change of use would be for a children's residential home. There'd be a maximum number of 2 children with round-the-clock care assistance. Care would be provided by 2 supervisors during daytime hours with 1 supervisor during nighttime hours. Shift patterns for supervisors would run 10 a.m. to 10 p.m, 10 p.m. to 10 a.m. The care home will be for children that are unable to live with their birth families. There are no internal or external changes proposed for the site. It is considered by officers the building will appear as a residential property set within a residential street due to this. When considering the potential for crime and antisocial behaviours to arise, given the level of care, officers would recommend there are suitable measures to prevent a material decrease to the quality of life for neighbouring residents. A staff-to-child ratio of 1:1 is considered to be appropriate. Children will be allowed independent time within the community. They'll be equipped with a mobile phone for communication and will have a curfew that will be set as per the child's care plan. It was raised by a number of objectors that the street is not a suitable place for children in care. The street is formed of residential properties, many of which are suitable for family living. The wider site is within a new build residential suburb and there is appropriate access to the surrounding green spaces. The internal layout of the building will remain unchanged from the time of construction. All habitable rooms on the plan have window openings and there is adequate natural light for future occupiers. The internal layout does not have specific staff facilities, however, it does not indicate specific staff facilities. However, overnight staff would have accommodation and sleeping facilities in one of the bedrooms and there'd be separate washrooms for staff and children. The kitchen is available for everyone to use. In terms of noise and general disturbances to neighbouring properties, given the number of children and staff, it's not considered there be a material increase beyond what would be reasonably expected from a residential property. Therefore, officers have no significant concerns regarding the impact on residential amenity. In relation to highways, Kirklees Council Highways Development Management have been consulted in respect to the application. They have no objection in terms of the impact the proposal will have on the safe and efficient operation of the road network. The property currently benefits from 2 off-street parking spaces to the front of the property, which is sufficient to accommodate for the total number of supervisors present during shift patterns. There may be times when additional vehicles will arrive at the site, such as when associated professionals visit. Parking can be accommodated adjacent to the driveway without impeding neighbouring driveways. In addition, Kingfisher Way can accommodate parking. The number of visitors is not considered to be over and above what would reasonably be expected from a residential property. Professional visitors would be required on a child-by-child basis as per their care plan. This proposal has been assessed against all relevant local and national planning policies. For the reasons outlined fully in the committee report, the proposed scheme is recommended for approval, subject to conditions. Thank you, Chair.
Thank you, Edward. We have one speaker joining us on Teams.
Hello.
Hello.
Hi, my name is Amira. I'm one of the shareholders for this proposed business planning permission.
Good afternoon, Humera. Welcome to the meeting. You have 3 minutes to present your case, and we're ready when you are.
First and foremost, I would like to stress that the dwelling is no different to a normal family setup that you'd expect to see in a 3-bedroom family home. We have proposed a maximum of 2 children with 2 people on day shift and 1 on the night shift. We have also confirmation from the neighbours who are directly attached to the property that they're happy with the plan and have no objections. The approval of the planning would also allow to home a child who unfortunately has come from deprived home backgrounds to live in a good neighbourhood with a second chance in bettering their lives. This would also open a home for the council to home an underprivileged child, something that the council is in great need of. The parking issues that have been brought up by the objections, it shouldn't hold any weight as Edward has said, that the property does have its own 2 parking spaces belonging to the property, and that should be enough parking for the 2 people that should be on shift during the day and 1 at the night. There may be obviously visitors probably like once a month, which like Edward has mentioned, we have got 18 Kingfisher Way has a capacity of off-site parking. Also, that would be quite normal. If a normal family was living in a 3-bedroom household, they would have visitors in and out. So we would be grateful if you did pass this application regards to the objections. Obviously, Edward has had a site visit and he has brought up a documentation of the committee on the planning permission website under the committee link of why he, with objections, and why he feels the objections shouldn't hold weight. I have had a read through that as well, and it does show that our plan is obviously well under our rights of changing the dwelling. Thank you for having me on today.
Thank you, Humera. Thank you for your comments. Councillor Joe Lawson, then Councillor McGrath, and then Bellamy. I think I got that order.
Thank you, Chair. These are obviously family homes. When a family moves in, it's not limited to how many children that there will actually be there. You could, in a 3-bedroom house, say, have 4 children, mum and dad, loads of visitors coming and going. I feel that there is some scaremongering going, that children are put into care because of them and not their circumstances. Haven't children got a right to live in a family home, which this would be? They're going to be well supervised, probably better so than some teenagers living maybe a few streets down the road there. And I personally feel quite horrified that people object to what would be 2 children living a normal life. Thank you, Chair.
Thank you, Councillor Lawson, Councillor McGrath, and then Councillor Bellamy.
Echoing a lot of what Councillor Lawson said there, I mean, wouldn't it be awesome if, you know, every next door neighbour had a curfew of 11 p.m, shift patterns for people coming and going from 10 a.m. to 10 p.m. they'll be allowed independent time in the community, but they'll be monitored. They're only allowed to have 2 children, but they're not going to be crying babies. There's so many things in here that I would recommend, you know, when I buy a house for my next door neighbour, which obviously can't do. Whereas in this plan, it does it for, you know, the parking, the number of people coming and going. It's almost the perfect neighbour moving in. So as such, you know, I'm proposing we pass this, and almost a no-brainer.
Are you formally moving the recommendation, Councillor McGrath?
I'm going to propose it, yes.
I'll second it.
Okay, we've had a few seconders. Okay, Councillor Bellamy and then Councillor Sokol.
Yeah, I were going to more or less say the same thing. I mean, a care plan is a lot stricter than what parents can do with their own, usually. And it usually works that way as well. So it's a normal house. It's basically going to end up still more or less the same thing. Okay, it's called a care home instead of just a house. It's 2 children. There'll be 2 adults at the most there. Isn't that a family unit? It is in my thinking. It's a lot better than a massive, great big care home. So I think this is the way that we should be going anyway as a council. You know, care homes should be for 2 children with 2 adults there. It's a family environment, and absolutely. I mean, I'd have it next door to me straight away. So, yeah, I'm happy to second.
Thank you, Councillor Bellamy. So it's been moved and seconded by Councillor McGrath and Bellamy. Councillor Sokol to speak next, and then Councillor Sully-Ridge.
Yeah, Chair, I'm not against this application, but I just want some more information. It doesn't mention the age of children, how old the children, or I might have missed the report somewhere. And I should not ask, or I might be, I can ask, is the disability of those children? Is no criminality involved? Yeah, something like that. And just need some information on that.
Criminality.
Yeah. Thank you, through you, Chair. I'll just remind members that this is a planning committee, so in terms of the descriptions that you're asking for, it's not really for us as planning officers and for you as planning members of the committee to be looking into these things. They're under 16, they're children. We don't have this particulars on the types, nor would we ask for in terms of planning issues. These matters are more likely to be covered by other regulatory functions outside the planning system, like the Care Commission.
I'm going to say you wouldn't know the age of children moving in if the house had just gone up for sale, would you? And you wouldn't know whether they've got any criminality either. So.
That's fine. Okay, we will move on. Councillor Sully Richards and Councillor Eric Firth next.
The only thing I wanted to ask was, these are going to be long-term residents, not going to be changing the 1 or 2 of the children every couple of weeks. It's going to be a stable environment for these youngsters.
Thank you, Councillor Firth.
Thank you, Chair. For a start, I had great difficulty in hearing the applicant. I think they were a terrible line, and obviously it was supposed to be a Teams link, and we could hear her a bit, but we couldn't see her because it wasn't clear what she was saying. But one of my concerns, and I know it's not a planning issue, is that this is a private company that's set up in this home, and I just would like to know if the Kirklees children that are being looked after, and if the applicants or that are running this home have some kind of history. It's not for this, I will take it up with social services. But by the same token, the kids are going to be issued with a mobile phone, so they're going to be not little ones. That's what we said. You know.
Okay then, Kirsty, Council.
Thank you.
Yep. Kirklees.
Oh, sorry.
Just one question from me, Chair, and I'm not even sure if it's quite relevant, but it's just about the setting the precedent for the rest of the estate and the change of use. Is that something we need to be aware of or consider?
So I'll take, I think you know my answer to the first comments in terms of the stable environment, and it was the long term and the the applicant. Again, it's, as I've said before, it's these matters would be covered within regulatory functions outside the planning system, be that the Care Commission or, you know, the Social Services Department of Kirklees Council. It's not for the planning system to monitor these type of stipulations. Whilst it's an important matter, it's not a planning matter. In terms of precedence, what I would say is that every application is assessed on its own individual merits, and any application that would come along would be assessed as such.
Thank you, Kirsty. I think that brings us to the end of the comments. I think it's been moved and seconded by Councillor McGrath and Councillor Bellamy. I think we'll move to the vote. Thank you.
Okay, so the vote is on delegation of the application to, delegate to approve the application. Councillor Sokol?
For.
Councillor Firth? Councillor Davis? For. Councillor Lee Richards?
For.
Councillor Bellamy?
For.
Councillor McGrath?
For.
Councillor Lawson?
For.
Councillor Uller?
For.
That's carried.
Yeah, no problem. Yeah. Okay. All right. Okay, we're at the last application then. Page number 149, demolition of existing mosque.
Thank you, Chair. Sarah Longbottom, case officer for this application. Members visited the site this morning, and it comprises a mosque and education centre with associated car park. A local shop is attached to the north, with a commercial unit to the south, and the remainder of surrounding development being residential in nature. Permission is sought for the demolition of the existing building and the erection of a mosque and education centre. The application is brought to committee due to the significant number of representations received, and these are set out within the committee report. The concerns raised primarily relate to highway safety. There have been previous permissions for extensions to the existing building, and the slide currently up now shows that previous approval. This lapsed earlier this year. It became apparent that it was not possible to implement the previous permission as the whole building would need to be demolished, hence the current application. Just going back to the current proposal. This would result in a building of the same height, depth, width and overall design as that approved under the previous permission, albeit with a slightly different internal layout. The proposed materials would comprise artificial stone to the front elevation and brick to the side and rear. And this is considered to be more in keeping with the character of surrounding development than the previous approval, which included some elements of render. As such, the impact on residential and visual amenity is considered to be acceptable and in accordance with relevant policies. The slide just up now just shows that relationship, the section with existing development, and that's with the residential properties on Ravenshouse Road, to the front and the rear. And as I've already stated, that relationship has previously been accepted as being, the principle has been acceptable. The separation distances are in excess of 25 metres to the properties to the east and in excess of 20 metres to the properties to the west. Through the course of the application, amended plans have been received showing a reduction in the amount of accommodation proposed, and this involved the removal of classrooms and ladies' rooms at the first floor level, which officers considered would have resulted in intensification in use. Classes are to be taught in the subdivided part of the prayer hall on the ground floor, and there is to be no increase in worshippers. At the time of the previous application, the car park was not included as this was the subject of a separate application at that time. It is now included within the red line boundary of the current application, and members would have seen that on site today, and can provide 23 spaces or more if cars are stacked. Additional highways information has been received through the course of the application, including parking surveys. Whilst the findings differ slightly to officer observations and existing highway issues are noted with on-street parking during prayer times and drop-off pick-up times for the education centre, the proposed development is not considered to result in a significant intensification in use of the site. Officers recommend conditions to include the submission of a car park management plan and a construction traffic management plan. So to conclude, the recommendation is for approval as set out in the officer report. Thank you, Chair.
Thank you, Sarah. One speaker, Mr. Imtiaz Amin. Welcome to the meeting, Mr. Amin. You have 3 minutes.
Thank you, Chair, and good afternoon. The details of this application are set out fairly comprehensively in the delegated report in front of the councillors. Ms Sarah Longbottom has further expanded on that, so I don't need to really say anything further on the actual details. The reason this application is before you is because in 2021, in July, the mosque application was approved with partial demolition of the existing building. One of the conditions attached to that permission was to deal with contaminated land on the site. We instructed engineers and environmental health experts to deal with that particular matter. After their investigation, they reported that they could not conduct the decontamination and remedy the site without having access to the entire footprint, and therefore that partial demolition was inadequate. Following those findings, we had a meeting with council officers to discuss the planning application. The outcome of that meeting basically was that we could not proceed on that application because the remedial work required for the contaminated land could not be carried out, and therefore that application, basically that planning permission, was void. So we had to resubmit the application, and the only change that was significantly made was that instead of the partial demolition, we now have the entire demolition of the building, so that the contamination that requires remedial work can be done for the entire footprint. With the exception of that, there is no significant changes. In fact, as the officer said, it will be more aesthetically pleasing and in keeping with the residential amenity. We have no desire to increase the number of worshippers or the number of children who attend the education centre. We focus more on quality rather than quantity, and councillors will be aware from their research in education that those children who attend supplementary schools, who do extracurricular activities, who engage in sport, tend to do well when it comes to their exams. And we have seen it over the last 10-15 years that those children who've been attending our education centre have now graduated, and we have many that who have qualified as engineers, IT technicians and teachers. So we focus on the quality of education we provide, not on the numbers. And as the officer said, there will be no increase in numbers. We simply do not just take everybody on for the sake of taking them on. We want to make sure that every child who comes there, attends there, ends up with a good quality education. We have the number of worshippers have stayed steady for a number of years, and we don't envisage that increasing because there are, as you know, there are many mosques around North Kirklees within walking distance of people who live there. So, in conclusion, I humbly request the committee to approve the application in line with the officer's recommendation. Thank you very much.
Thank you, Mr. Amin. There are no other speakers, so we'll move to the committee. Councillor Sully Richards and then Councillor Bellamy.
Thank you. When we looked around the site, now that it has the car park within the site, it's possible that the proper car parking management plan will be put in place to ensure that the busy road isn't obstructed by too many vehicles. And the other thing I wanted to just ask was, walking around the back of the building, it did have looked like a small amount of parking behind the building. Is the replacement building going to be on the same footprint as the existing building?
Thank you, Councillor Lee Richards. Councillor Bellamy and then Councillor Davis.
Thank you, Chair. I'm under the impression that I think it was said that the building will be the same footprint, so it isn't going to be any different. and a car parking management plan would hopefully be included. If that is the case, to be honest, I'm more than happy to move the recommendation.
Okay, so we've had a formal move for recommendation for the application to approve. Councillor Davis, and then Firth, and then I think Joe. So Councillor Davis.
Thank you, Chair. My question is just about numbers of visitors to the mosque and the education centre. I know we've said there's not intended, they don't think there'll be any increase, but what are the regular sort of numbers attending? So I've got a better feel for what the traffic implications are. Is that something to be asked?
Thank you. Councillor Firth, and then Councillor Lawson, and then Councillor Sokol.
Thank you, Chair. My only concern is highway safety in this area. As you all know, it's very popular.
Thank you, Councillor Firth, Councillor Lawson, and then Councillor Sokol.
Thank you, Chair. From what I can gather, that there is not going to be any significant impact on the numbers attending, is with the education and with the actual mosque itself. Is I know from observing, I think it's Najis Usman in Springwood, they have a really good parking system guiding people around the thing there, and hopefully that could be something, if it's not already in place, that you actually look at, and obviously encouraging as much people to try and park in the building there. But this has been established for a number of years. It's not something new, so it shouldn't really impact the people living there. And I would actually move to the vote.
So it's been moved by Councillor Bellamy. I think Councillor Lawson seconded that. Councillor Sokol next then, please.
Thank you, Chair. When I got on the site visit this morning, I found the car park is very unsightly in appearance, There's a lot of vegetation ground and some rubbish around there. I don't know why the mosque people not take any notice of that. What I'm looking for, this mosque is not going to be a new mosque. It's a replacement of the old mosque and the same footprint. I'm not against that, but I would like in future, so they should give take more notice of the car park and improvement on the car, so it looks nice to neighborhood. So I'm happy to go along with my colleagues.
Okay, thank you. Councillor McGrath, and then Kirsty's going to come back on a couple of points that were made.
Sorry, I was just going to follow up. Essentially, what's the capacity of the building, and what's the enforcement levels based upon the monitoring of that capacity being adhered to? Because obviously we're saying it's not going to grow, but a nicer, newer building with a growing population around it. If numbers start to increase, what are we saying about that? Have we got things in place to make sure that the number of users remains the same? I imagine there is. I just want to make sure that it's involved in that. And what's the capacity of the building?
Thank you, Councillor McGrath. Councillor Firth, and then Kirsty's definitely going to come back with a few bits.
Thank you, Chair, for giving me the opportunity to come back. I know the area pretty well, Councillor Lawson, and this parking highways problem has been with us for a long time. Against the new mosque being built, but I see this as an opportunity to find a way of controlling the parking and the highway situation there. And it's to the advantage of the mosque or the elders that run the place, and it will endear them forever to the local community because it's heavily congested. A lot of people live around the mosque, and it'd be very welcome, I assure you, if you can sort the traffic out and the people that use it. You know, it will go down very, very well with the local community.
Thank you, Councillor Firth. Kirsty?
Through you, Chair, so just to pick up on a couple of points. In terms of the car parking management plan, that's condition 11. So that is to require a parking management plan. And as we said when we were on site, and I'll just reiterate it for those members that weren't, this is a standard that we have for certain types of planning applications and would be submitted approval prior to the first occupation. In terms of the capacity, there'll be no additional capacity. I don't have specific numbers, but what I can say is that the facilities that are being made available to that existing, that approved in 2019, isn't increasing, so won't exacerbate any existing situation. And that's to do with the number of visitors as well. So the car parking and all the additional information that was submitted was assessed as acceptable and isn't increasing as part of this application. In terms of the car parking and the design, etc., as we discussed on site, you know, for it to be made into a car park, these are, you know, things that would be included within that. So I hope that answers all your questions. If you do have anything else, just let me know.
Thank you, Kirsty. I think that's been really clear in what you've said. I don't think there's any further comments or questions, so I think we will move to the vote. Please, Andrea.
Okay, the vote is to delegate the approval of the application. Councillor Sokol?
For.
Councillor Firth? Councillor Davis? Councillor Lee Richards?
For.
Councillor Bellamy?
For.
Councillor McGrath?
For.
Councillor Lawson?
For.
And Councillor Uller?
For.
That's carried. Thank you.
Thank you. That brings us to the end of the meeting. Everybody, thank you for your attendance.